The debate over Uniform Civil Code has taken center stage since the 22nd Law Commission of India issued public notice last month inviting all stakeholders, including religious bodies, to send in their opinion on the subject. The move has faced resistance from some quarters, with critics claiming that bringing up the matter is an attempt by the ruling party, that is the BJP, to polarize the electorate ahead of the 2024 Lok Sabha elections. Some say a uniform civil code violates religious freedom. So, what is the UCC? UCC is mentioned in Chapter 4 of the Indian Constitution, which contains the directive principles of state policy or DPSP. These principles act as guidelines for the government when creating new laws. However, unlike the provisions in the Fundamental Rights chapter, citizens do not have any legal authority to compel the state to adhere to the DPSP. If implemented, UCC will outline a common code and govern various civil practices such as marriage, divorce, succession, and adoption. Currently, India's diverse personal practices vary based on religious affiliations and community backgrounds. As the UCC continues to fuel intense discussions, what are the various aspects of personal laws, some of which are likely to be subsumed with the UCC? Wedding festivities in India come in diverse hues, and so do the legal frameworks governing a couple's divorce, where faith informs the law. In this first episode of a two-part series, here are some of the legal frameworks governing divorce and maintenance for Hindus, Muslims, Christians, and Parsis. Let's first talk about diversity in divorce. From the Saat Feras to Nikah, religion holds significant sway over marriages in India, shaping the ceremonies and rituals. While the registration of marriages is essential for legal recognition, the absence of a registration does not invalidate the union. Consequently, in cases of separation, couples must pursue legal remedies that vary from religion to religion. Divorce procedures are guided by community-specific legislations, which outline the circumstances under which a court can grant divorce to a couple. Under the Hindu Marriage Act 1955 or HMA, a couple that marries as per the community's rituals can move the court for divorce on the grounds of either adultery, cruelty, desertion, religious conversion, mental disorder, leprosy, venereal disease, renunciation of worldly attachments, not heard alive for a period of 7 years, or if there is no resumption of cohabitation after a court order of separation is passed. The Act includes Sikhs, Buddhists, and Jains under the definition of a Hindu. The law also lists out extra grounds in case a wife wants divorce. These grounds are if a husband has engaged in an act of rape, bestiality, or sodomy. In case the husband marries another woman, if the wife was married before of the age of 15 and renounces marriage before she attains 18 years of age, if there is no cohabitation for 1 year, and if the husband neglects a court judgment of maintenance awarded to his wife. In Muslims, a husband can unilaterally divorce his wife by repudiating the marriage without giving any reason, simply pronouncing the word talaq to indicate his intention to dissolve the marriage is considered sufficient. The husband can divorce the wife by a single pronouncement of talaq during tuhar, which is the period between wives' 2 menstruation cycle. During this period, the husband should not have had any sexual intercourse with the wife. In the second form of talaq, the husband can make 3 pronouncements, one during each of the successive 3 tuhars. To be sure, the husband cannot follow the practice of instant triple talaq that was first outlawed by the Supreme Court and then the government after it criminalized the practice. However, the two Muslim sects, Sunni and Shia, follow separate procedures for talaq. While Sunni law says a talaq may be oral or in writing, in Shias it must be pronounced orally in the presence of two witnesses except where the husband is unable to speak. In contrast, a wife cannot divorce her husband of her own accord. A Muslim wife draws this right through the Dissolution of Muslim Marriages Act 1939, which is a British-era law. The grounds that entitle her to obtain divorce are if the husband is missing for 4 years, if the husband has neglected or has failed to provide for her maintenance for 2 years, if her husband has been sentenced to imprisonment for 7 years or more, if the husband has failed to perform his marital obligations for 3 years or more, if the husband was impotent at the time of marriage, or if he suffers from leprosy or a virulent venereal disease. A Muslim woman can also ask for divorce if she is married by her father or other guardian before she attained the age of 15 years or repudiated the marriage before turning 18. This ground is available if the marriage has not been consummated. A wife wanting divorce on the ground of cruelty in the Muslim law should be able to establish one or more of several conditions, which are that her husband habitually assaults her, associates with women of ill repute, leads an infamous life, attempts to force her to lead an immoral life, dispossesses her of her property or prevents her exercising her legal rights over it, obstructs her in the observance of her religious profession of practice, or if he does not treat her equitably with his other wives in accordance with the Quran. In case a husband levels false charges of unchastity or adultery against his wife, then the latter has the right to ask for divorce on this ground as well. The Dissolution of Muslim Marriages Act 1939 does not allow a wife to ask for divorce on the ground that the husband neglects if she lives separately without any reasonable excuse. Another colonial era law, the Indian Divorce Act 1869, regulates divorce proceedings for Christians in India. Amended in 2001, after various courts nudged for it, the Act allows filing for divorce on the grounds of adultery, cruelty, desertion and religious conversion. Such a petition should be supported by evidence which could include affidavits from witnesses, letters or other documents that prove that a spouse has been unfaithful or meted out mistreatment. The Act lays a lot of emphasis on adultery and warrants that the petitioner to make an adulterer or adulteress a correspondent in the divorce petition, unless excused by the court. In case the petitioner, which could be either of the two spouses, is found guilty of adultery or deserting the partner willingly, then his or her plea for divorce gets rejected. However, if conjugal cohabitation has been resumed or continued after one spouse has committed adultery, then adultery cannot be invoked as a ground for divorce in this law. The Indian Divorce Act frowns upon collusive petitions filed for divorce and empowers courts to reject such suits. Broadly, this refers to a divorce petition where both parties act in concert to mislead or deceive the court in some way. The Parsi Marriage and Divorce Act 1936 requires registration of a divorce decree. Only 3 grounds of divorce are prescribed in the law. They are non-consummation of marriage for a year due to the deliberate failure of the spouse, mental illness or unsound mind at the time of marriage and on the date of filing of the petition, and the wife's pregnancy at the time of marriage by someone other than the husband. The third ground, which is where a wife gets pregnant before marriage, can be invoked within 2 years of the wedding date, and only if no intercourse has taken place between the couple after the husband learned about the wife's pregnancy. A notable aspect of Parsi law is the establishment of matrimonial courts, specifically dedicated to handling divorce proceedings within the community. Additionally, delegates appointed by the state government, who are members of the Parsi community, themselves contribute to the adjudication process of divorce cases. What about divorce by mutual consent? The option of mutual consent divorce is permissible under all personal laws. However, the procedure and the mandatory separation period required before filing of such a petition vary from community to community. Hindu and Parsi couples can move a mutual consent divorce petition a year after living separately, while for Christians, this period is 2 years. While a Parsi couple cannot file such a petition within a year of getting married, there is no such bar for Hindus. Unlike Hindu law, which requires a 6-month cooling off period between the filing of the first and the second motion in a divorce case, no such waiting time is mandated for Parsis. In the case of mutual consent divorce among Muslims, there are two procedures, Khula and Mubarat. In Khula, the wife initiates the divorce by making an offer which the husband accepts. In Mubarat, both parties agree to mutually free each other from the marriage. In both Khula and Mubarat, the wife relinquishes either her or entire or a portion of her dower, which is the money or property given by her husband at the time of marriage. Following a divorce, a Muslim woman must observe a period of chastity called iddat for 3 months before she can remarry. Coming to maintenance for women and children. The provisions regarding maintenance vary across different personal laws. However, there is also a secular law in section 125 of the Criminal Procedure Code or CRPC, under which maintenance can be claimed by the wife, children and parents. As far as personal laws go, 2 laws are available to Hindu women for maintenance. They are Hindu Adoption and Maintenance Act or HAMA of 1956 as well as the Hindu Marriage Act or HMA. While HAMA is specific to wives, the HMA allows a husband also to ask for maintenance from his wife in case he is incapable of supporting himself. Under HAMA, a husband is obligated to provide maintenance to his married wife throughout her lifetime, even if she is living separately but is not divorced. HAMA also grants maintenance rights to dependents such as widowed daughters or daughters-in-law, stepmothers and minor legitimate or illegitimate children. Maintenance provisions under HMA differ. Under this law, either the husband or the wife can claim maintenance, although the parameters for deciding it are gender specific. It is worth noting that various progressive judgments by courts have extended maintenance rights to a second wife, albeit in exceptional circumstances such as misrepresentation by the husband regarding his first marriage. Christian and Parsi women are entitled to similar maintenance rights as Hindu women under their respective personal laws. Both the Indian Divorce Act and the Parsi Marriage and Divorce Act contain provisions that grant maintenance, alimony pending litigation, and a permanent maintenance amount as well. Under Muslim personal law, on the other hand, a husband who divorces his wife is obligated to provide maintenance only during the period of iddat. In common practice, maintenance typically covers the wife's food expenses. Usually, the payment of dower has been considered sufficient for maintaining a divorced wife. However, Muslim personal law has evolved through various court cases, leading to the recognition that reasonable and fair maintenance should be paid to women within the iddat period. Courts have emphasized that dower is a symbolic gesture of respect for the wife and cannot be construed as maintenance. They have further clarified that the maintenance amount should be sufficient to support the wife for her entire life. This is all that I have for you right now. Thank you very much for tuning in. Do look out for the second part of the series on how personal laws affect our lives and how the Uniform Civil Code could subsume these practices.